The High Court has ruled that Aboriginal Australians are not aliens for the purpose of the Constitution and cannot be deported even if they're not citizens. The government was seeking to deport Daniel Love and Brendan Toms for serious crimes committed in Australia. Both the men were born overseas with neither holding Australian citizenship, but they self-identify as Indigenous and argued they shouldn't be considered aliens under immigration law. In a 4-3 split decision, the High Court has ruled in their favour, declaring Aboriginal Australians have a special connection to the country and cannot be deported, regardless of whether they hold citizenship or not. But it was a split result for the plaintiffs. The High Court was only able to determine that Mr Toms was Indigenous, with Daniel Love's Aboriginal identity now the subject of future hearings. The Greens are welcoming the decision but say it should never have been necessary.
It does raise the issue of on what planet, a white minister could make a decision to try and have an Aboriginal person declared as alien in their own country. It says an awful lot about the government and the minister that they would take a decision to effectively try and deport someone from land that we in effect stole from them 200 years ago, and it's very hard to see this decision in any other context than a racist decision by government.
Let's get some analysis. Constitutional law expert Anne Toomey from the University of Sydney. What did you make of the ruling? Did you expect this? And as I said in that introduction, it was a split decision.
Yeah, it is a split decision, and I think it's actually a genuinely difficult issue. And we can see that people who are intelligent and well-meaning can take different views on it, and that's certainly what's happened in the High Court. So it was a close decision. It was 4-3.
Indeed, and the two individuals concerned, the sort of rap sheet that they had or have would see any other non-citizen deported, as we've known. The Home Affairs Minister's done that on 5,000 separate occasions. So that wasn't out of step with his approach when it comes to non-citizens found guilty of serious crime.
That's right. So in the past, quite a number of people who've lived in Australia for most of their lives but are still non-citizens have been deported on what are known as character grounds, and that means that you've been convicted of a relatively serious crime. In this case, it was a crime of assault causing bodily harm, and on that basis, were it not for them being Aboriginal Australians, they would have been deported.
And so when it comes to the Aboriginality of the individuals, how does the court go about working that out or establishing that, given both of them weren't citizens?
Yes, so the court uses a three-level test, which had previously been identified, first in the Tasmanian Dams case back in 1983 and again more recently in the Mabo case. And so the steps involved are, first of all, you have to have biological descent from Aboriginal people who were historically here at the time of first British settlement. Secondly, you need to identify yourself as an Aboriginal person. And thirdly, and critically, you need to be accepted within the Aboriginal community by the elders or people who have authority, traditional authority within that community, to recognise who the members of that community are. So it means it's not just a case of people self-identifying and say, I feel like I'm an Aboriginal person today, therefore I can do X. The test involves elements of biology, self-identification and identification by the elders of the Aboriginal community involved.
And obviously these are quite unusual circumstances, are they not, in terms of having Aboriginal individuals, Aboriginal men who aren't Australian citizens?
That's true. It is. It's quite unusual. So it occurred because each of them were born outside Australia, but each of them had relatives or were descended from people who were Australians, but because of the circumstances of their birth, they did not of themselves initially be treated as Australians, but they were entitled at different stages to apply for Australian citizenship, and so that was one of the problems. Historically, their family didn't apply for citizenship for them, and that left them in this rather awkward position now.
Yep, and Professor Anne Toomey, constitutional law expert from the University of Sydney on that very interesting story. Thanks for your insights on that today. Appreciate it.